All right, good morning, everyone. We'll go ahead and get started here. Good morning and welcome to Notre Dame Law School. My name is Nicholas DeAndre, and I am Editor-in-Chief of the Notre Dame Law Review. It is my pleasure today to open today's Religious Liberty Symposium. The Religious Liberty Symposium is the first of 3 symposia organized by Volume 98 of the Notre Dame Law Review this year. The articles and essays discussed today will be published later this academic year through Volume 98 of the Notre Dame Law Review Reflection, the Law Review's online supplement. Every year, the Law Review invites preeminent scholars to contribute to an academically rigorous and diverse discussion on an important legal issue, and today is no exception. Our topic today is unconstitutional conditions and religious liberty. To what extent can the government burden religious exercise and belief as a condition of receiving a public benefit or participating in a government-funded program? And when conditions burden religious exercise, which interests should prevail? We are joined today by 8 excellent professors who will be discussing their scholarship on this topic. These professors are Professor Thomas Berg from the University of St. Thomas Law School, Elizabeth Clark, Brigham Young University, J. Reuben Clark Law School, Marc DeGirolami, St. John's University Law School, Michael Helfand, Pepperdine Caruso School of Law, Michael Moreland, Villanova University, Charles Widger School of Law, Lloyd, Notre Dame Law School, Lucia Silecchia, Catholic University of America, Asma Uddin, visiting professor at the Catholic University of America, Columbus School of Law as well. I am thankful to the Religious Liberty Initiative for their sponsorship of the Law Review's Religious Liberty Symposium for the 2nd year in a row. And thank you as well to all the hard work of Courtney Klaus and Lorraine Buckner, symposium editors for the Law Review, who made this event possible. Today's program is being recorded and will be available online following the symposium. And lastly, thank you to our moderators today, Professor Nicole Garnett, John P. Murphy Foundation Professor of Law at the Notre Dame Law School, and Professor Rick Garnett, Paul J. Sherrill, Fort Howard Corporation Professor of Law at the Notre Dame Law School. And with that, I'll pass it over to Professor Rick Garnett. Please join me on welcoming our first panel.
Well, the only job I had was to introduce the speakers, and Nicholas already did that, so I guess I'm off the hook. But let me just add a quick word of thanks to all of you on the Law Review for making this happen. Not only did you invite some great scholars to talk about an important topic, but you also invited a lot of nice people who I enjoy connecting with. So selfishly, my thanks to you. The topic for this panel is, quote, the doctrine of unconstitutional conditions. That doctrine has been called by commentators muddled, opaque, inconsistent, and confused. That's the nice stuff, people say. But here to shed some light on that muddle is our first panel. And as you've heard, we're joined by Professor Thomas Berg, Professor Elizabeth Clark, Professor Marc DeGirolami, and Professor Michael Helfand. All of them are talented, all of them are accomplished, all of them are nice, and this introduction will not do justice to their accomplishments. That's what Google is for. So we will start, since this is Notre Dame, we follow the natural law, which means alphabetical order. And we'll start with Professor Berg.
Thank you. It's wonderful to be here. Always really nice to come to Notre Dame. Especially nice to come in the fall, not on a football day, but on a day when the leaves are as beautiful as they are. I'm from Minnesota. The leaves were beautiful 2 weeks ago up there, so I enjoyed that. And I've come here and I can see the leaves here. So if anybody knows a place that I can go a few hundred miles south in a couple of weeks, please let me know so that I can keep seeing the autumn leaves wherever. But it's great to be here. So my paper is called The Free Exercise Renewal and Government Benefits. And the premise of it is that there has been a renewal of the strength of free exercise of religion in the Supreme Court in the last few years. I say not a revival, because free exercise of religion was never dead in the court, but it was under some threat, at least under some interpretations of doctrine. But in recent years, the Supreme Court has reinvigorated free exercise of religion. And so my question is, how might those doctrines and that kind of attitude towards free exercise of religion, that it's a very important right and ought to be protected strongly, what will that mean for upcoming cases about government benefits, whether that's tax exemptions or funding or the student organizations meeting on public university campuses, which are characterized as a benefit in cases, in the Supreme Court's cases. So this is going to be very abbreviated here, obviously, in this short time. But I divide the universe of cases into two kinds of conditions on government benefits, because that's always the issue, right? Is government provides a benefit and then there's some condition accompanying it, and that may conflict with religious freedom, or at least that's usually the issue. So I divide them into the situations into cases of conditions that are discriminatory against religion, and those that might be called conditions that are generally applicable, but nevertheless could conflict with a religious tenet, and might therefore burden the recipient's religious freedom. Anti-discrimination laws, conditions on benefits probably, at least in many cases, fall in the second category. But I'm going to start with the first category very quickly. And the set of cases that are most relevant to that in recent years is the three cases in which the Supreme Court has said that the government, when it provides funding to private organizations, it can't exclude an organization from eligibility on the basis that it is religious. The latest of those decisions was just this last June, Carson versus Macon, which said that schools, religious schools cannot be excluded from a program of providing tuition for private schools in the state of Maine. And so my question again is, what might be the next step in terms of conditions that might be considered discriminatory against religion in the way that that condition was, right? A private school could receive tuition money, but not if it was sectarian or engaged in religious teaching. And my suggestion is that actually this court might be willing to extend that to an important set of conditions that appear fairly often, which is a condition on a recipient discriminating on the basis of religion in its activities. So if you receive funding, or if you are a student organization that gets access to rooms on a university campus, maybe receives funding from the university. But as a condition of that, you can't require that your leaders be of a certain religion, because that's religious discrimination, or can't require that they adhere to the faith of your organization. My argument is that, as applied to religious organizations, that is in fact discriminatory against religious organizations, because it means, by the face of the law, that the one organization that can't require that its leaders and members adhere to the beliefs of the group, the animating beliefs of the group, is a religious organization. The student environmentalist group can require that its officers and members sign a commitment to protecting the environment. But because the condition focuses on religious discrimination, which is religion is itself a belief and an animating belief for an organization, religious organizations become the one group that can't demand that kind of commitment. I think this court might actually be willing to take that step and call that discriminatory under the previous cases. The second, how much time have I got?
You have 5 minutes left.
5 minutes left. Okay, good. Thank you. The second set of conditions are those that are generally applicable but as applied to a religious organization, may interfere with or conflict with its tenets. And these are probably the more common kind. So in part of the paper, I argue that we shouldn't conceive of religious freedom as merely a right against discrimination, that is, against being singled out for because you're religious in the way that the cases that I just mentioned involve. That religious freedom goes beyond that, and it protects the right of people and organizations to be able to pursue their voluntarily chosen beliefs without government favoritism, but without government pressure as well. And the classic case for this is in the Supreme Court's history is Sherbert versus Werner, which involved a Seventh-day Adventist woman who was unemployed and needed to receive unemployment benefits from the state of South Carolina, but could not take work that was offered to her on Saturday because that was her Sabbath. And in South Carolina in the early 1960s when this happened, people were working on Saturday. They weren't working on Sunday in South Carolina, but they were working on Saturday. And so the state said to Ms. Sherbert, you can't get unemployment benefits because you won't take the Saturday work. And the Supreme Court said that denial of benefits placed a substantial pressure on her to violate her faith because of the importance of unemployment benefits. There's a lot to say about this category, and it's hard to get into the details in this short a time. But I lay out in the paper that there are essentially three things that the court has looked at various points, three factors that the court has looked at various points to decide whether a burden like this should trigger close judicial scrutiny and be kind of presumptively unconstitutional. One is how serious is the deprivation from the benefit. In the case of unemployment compensation, it was quite serious. You literally need that in many cases to tide you over for the necessities of life. The second question is whether the benefit can be described as going to a particular program or activity of the recipient. This often comes up with religious organizations. Is the benefit or the funding going to some particular activity, or is that funding to a particular activity being used, as the court puts it, to leverage control over the entire organization? So sometimes funding is provided to one activity, but if the state uses that funding to one activity of an organization to say, if you engage in religious discrimination anywhere in your programs, you can't receive that funding, right? That's what the Supreme Court has generally called an unconstitutional condition, and goes too far and triggers strict scrutiny. There's a third factor which we can talk about maybe in the remaining discussion. But my suggestion at the end of the paper is that in two areas the court might be willing to say that conditions on benefits are unconstitutional under these kinds of factors. One is the withdrawal of tax exemptions for organizations that engage in discriminatory behavior. Withdrawal of tax-exempt status has a serious effect on the organization. It's not simply a withdrawal from one particular program or activity. It affects the recipient as a whole and therefore puts it in the Sherbert versus Werner kind of class. The other category that I think the court might be willing to consider is to overrule one of its decisions, one of its past decisions called Christian Legal Society versus Martinez, which was a student organization case where the court said a public law school could condition eligibility to be a recognized student organization, get access to rooms, get some funding. The law school could condition that on the organization opening itself up to anyone as a leader and not requiring a commitment to the ideals or beliefs of the organization. I think that case is ripe for overruling, again, because the effects on the organization particularly losing access to rooms and all sorts of media and connections at the school are quite serious. And because, again, a restriction on requiring beliefs from your leaders and affirmance of beliefs and commitment to beliefs from your leaders is a really serious burden on an organization. So I'll stop there.
Great, thanks, Tom. Professor Clark?
Sure. Thank you. Tom, it's too late to come see the beautiful fall weather in Provo. We had snow yesterday, so I'm enjoying life here very much. My paper takes a slightly different take on unconstitutional conditions, and you'll have to hold on because that's not where I start, but I do get there. Where I start, though, is looking at the value of recognizing a normative core to free exercise protections. In part, this is a response to Justice Barrett's concern in Fulton about whether there should be multiple tiers of scrutiny. And so if you think about that in other areas of law, levels of scrutiny are often based on the nature of the claim, such as the difference between political speech and other forms of speech. You know, is there some type that's more protected? And this hasn't been really the way we've looked at it in the First Amendment, but there may be some reasons to do so, and I suggest a few of them. I also suggest some possible evidence that the Supreme Court is actually doing this, just sort of sub rosa. So the four key ways that I use to sort of identify, well, what would be this normative core if it were to exist? One is looking at history, sort of what were the purposes of the religion clauses. And I take both of them because of the structural unity of them, because in many ways it's clearer to look at the Establishment Clause. There's a great article by Malcolm McConnell. He's going through sort of here's all the hallmarks of the English established church, and it seemed to be unlike free exercise clause history. This tends to be less controversial. Issues like government control over doctrine, structure, and personnel, mandatory attendance of religious worship, public financial support, prohibition of religious worship for other denominations, limitation of political participation in members of the church, right? So in terms of the free exercise context, I think that the same take on some of those concerns are the right to independence of doctrine, structure, and personnel, the freedom to attend or not attend to worship, the freedom to organize or belong to a religious organization of one's choice without injuring one's life, right to participate in public life. So there's more that can be done there. I'm not the historian, but I thought that's one interesting way to come at this. Another interesting way to come at this question is to take a more conceptual approach, logical. I mean, in many ways, this ties in with Michael Moreland's germaneness or Tom's centrality concerns. I'm a comparatist. I draw on international comparative law where there's this distinction between forum internum, forum externum. Forum internum is never been precisely defined, but it's usually understood to have an unlimited right to freedom to have or adopt a religion of your choice. And the international norms also state that no one should be subject to coercion, which would impair his freedom to have or adopt a religion of his choice. So this idea that there's a core cluster of rights that surround having or choosing a religion, sort of this voluntarism idea as well, that are at the core of what religious freedom protects. And then as it becomes increasingly sort of a manifestation in public life, it becomes less protected. So I would say looking at comparative and logical analyses, historical, you're looking at rights such as right, again, belong to a religious or belief community, right to publicly acknowledge one's beliefs, the ability to found a religious community, the right within a community to choose your doctrines, leaders, and teachers, and to be able to publicly share one's beliefs. So now I get to unconstitutional conditions. My suggestion is that in many ways, the Supreme Court's already been doing that it's been acting as though there is some kind of a minimal normative core that has higher levels of protection. How do we see this? We see this in two different ways. One is the way the unconstitutional conditions has been applied. It's been applied in a very sort of haphazard way. And when you look at it, at the cases, my take is that there's two different types of things going on. And Tom alluded to this in a slightly different way. But one are benefits that are part of the core rights to free exercise, even if you style them as benefits. And let me give an example, right? Say the benefit of running for public office, the McDaniels case, and that question of if you're a religious leader, can the government withhold this benefit of running for religious office? Well, that's just a fancy way of saying that is it or is it not part of the basic right as a religious leader to be able to participate in elections? It's not really an additional benefit they're choosing to give a few people, but it's part of the right itself. The other group is benefits that the state's not required to provide, but if provided, come with some kind of non-discrimination requirement. And this is sort of the Trinity Lutheran case. A lot of the school cases are this way. The government doesn't have to support private schools, but if they do, they need to do so in a non-discriminatory fashion. But looking at the ones that sort of, it seems tied up in with the right itself, the two that keep coming to mind to me, looking at these cases and also looking at the historical and sort of conceptual approaches, are autonomy, leadership roles, being able to select one's own leaders and have them be able to function in the public square, and proselyting. Looking particularly at cases of McDaniel and Cantwell. And then what we see is these are also rights that were protected even during the Smith regime, when there's supposedly very little protection. You think of the Hosanna Tabor case, religious autonomy. I mean, Smith distinguishes it, but really there's not a good explanation except for the fact that we think that the right to be able to choose one's leaders and teachers is really, really important. Which is just another way of saying it's part of the core. And what I'm suggesting is that maybe it's a little more intellectually honest to do that. And I think to some extent we also see it with proselyting, the Watchtower Bible and Tract Society versus Village of Stratton. There they do use free speech, and so it's a less strong example of my point. But I think the fact that it has been and continues to be protected indicates that it is part of a core beliefs. A core, normative core for rights to be protected under religious freedom. So, and then sort of using my comparative experience in the paper, I go through and I sort of cross-check and say, okay, does this line up with what's done elsewhere? Not that it needs to, but that coming from a shared intellectual heritage and conceptions of religious freedom, it'd be surprising if it weren't. And sure enough, rights to autonomy, rights to proselyting are the core of international norms, European Court of Human Rights cases, et cetera, et cetera, et cetera. Another right that falls in that core internationally that's really interesting, that's sort of where I end my paper, is a question about right to legal entity status. That's really well established elsewhere. But in the US, it's sort of problematic. I mean, first, I look at the question, okay, what is this legal entity status in the US? Are we looking at 501c3 or something else? There's not really a good alternative as a practical matter for 501c3, plus the religious freedom associated concerns that feed into the need for tax exemption. But there's this tension, right? We have Bob Jones that we've heard about that stripped tax exemptions, and under the way I've been using the unconstitutional conditions cases, that would suggest that it should not be part of a normative core, that government can condition it. It's just a benefit that needs to be applied non-discriminatorily, but otherwise we're not worried about it. But then there's this tension in the tax cases between Waltz and Reagan. We're going to hear more about tax cases in the next panel, but Waltz and Reagan, this question is, relief from taxation a core part of religious freedom that protects them from government, or is it just merely a benefit? And so the unconstitutional conditions in those cases come out very differently. And I'd suggest that it should be seen as a part of the inner core. But in any case, sort of there's some interesting comparative analysis about the non-discrimination, the Trinity Lutheran side of unconstitutional conditions, suggesting there's a great European Court of Human Rights case that is a nice counterpoint to Bob Jones, because they say, no, the government can't be in the position of dictating the beliefs or using the beliefs of a group to discriminate on whether they give it privileges or not, even if those are additional privileges. Stress the importance of the need to preserve pluralism, which includes respect for diversity and dynamics of cultural traditions and identities and religious convictions. And so getting back again to the conceptual basis of the core, preserving pluralism. So why does it matter if we have a normative core? Well, it lets us have higher tiers for core rights, such as religious entity status, perhaps, or certainly the right to choose one's own leaders and proselyte. And also allows you to distinguish and have a lower tier of review for ones that are a little more peripheral, having a for-profit religious group, having a not-for-profit group that's loosely associated with it, the religious entity. I would probably put religious education closer, internationally at least. It's accepted as a core right to be able to pass on one's beliefs to the next generation, but it is, of course, one that's been regulated.
Professor Clark, we probably need to wrap this one up and move on. So
Perfect. Sorry, I know I'm taking on. So finally, my last statement is just that I think it's worth remembering the lesson from Smith, which is if we protect everything at the highest level, which I think those of us who are here are instinctively like to do, it quite possibly leads to watering down protections for everyone. And so I think it may be helpful to pull out and think clearly about what it is we want to protect. So,
thank you. Professor DeGirolami.
Thanks, Rick. And it's a pleasure for me to be back here. I just want to start by thanking Rick and my fellow panelists, and also the Law Review and the Religious Liberty Initiative, and particularly Lou Ray and Nick and Courtney for putting all of this together. It's gratifying to be here and a pleasure to see you doing this important work on this important subject. My paper describes a feature of religion, the idea of mystery as a truth of religion that escapes human understanding. Mysteries aren't just truths that humans don't know, but in many religious traditions, they are truths that human beings cannot know in light of the human condition. And one of the most striking biblical passages, and I go through a couple of them I know as a Catholic, I'm not supposed to know very much about the Bible, but I actually did try to do a little research here. But one of the most striking passages concerning Christian mysteries is in Paul's first letter to the Corinthians, where he says, and I'm quoting here, "Howbeit we speak wisdom among the perfect, yet not the wisdom of this world, neither of the princes of this world that come to naught, but we speak the wisdom of God in a mystery, a wisdom which is hidden, which God ordained before the world unto our glory, which none of the princes of this world knew, for if they had known it, they would never have crucified the Lord of glory," right? So you see in this, close quote, so you see in this passage and in many others a kind of division between two different ways of knowing and understanding the human and the divine. In Orthodoxy, I have learned through the good graces of a colleague that the sacraments are actually called the mysteries. And of course, in the Catholic tradition, particular sacraments are referred to in the language of mystery, as when the Eucharist is called the mystery of faith. For non-believers and religious skeptics, it seems to me religion's mystery is a kind of proof of its unreality, its irrationality. While for believers, mysteries of religion are true just exactly because they are beyond human understanding. Okay, so what does all of this have to do with our technical subject here? Well, I suggest in the paper that something like this conception of religion, what I call a mysterized conception, has been adopted as a kind of crypto definition of religion in constitutional law. And that definition, I say, might alter the balance in some of the most contested questions facing the court. And I focus on the question of funding and benefits granted by the state on condition that private religious schools adopt non-discrimination policies respecting LGBT status and conduct for employees and students. And so I say, look, if you review the kind of clusters of doctrinal rules relevant to this issue, what I call the free exercise cluster and the non-discrimination cluster, there's a kind of equipoise in the doctrine. But that balance might tilt as a result of extra doctrinal factors, but it will also be affected by what I call religion's mysterization in cases like Thomas versus Review Board and Frazee. Religion in American constitutional law is not so much incoherent as kind of deliberately obscure. And I argue in the paper that the definition of religion seems to be exactly that it is a phenomenon ungraspable by or incomprehensible to the human mind or the human intellect. This is a sort of a central part of what renders it beyond the regulation of civil authority. It's the ground of religion's separateness from the secular, knowledge hidden from the princes of the world, as St. Paul had it. So quite apart from reasons of, for example, lack of jurisdictional power, which counsels against courts overly entangling themselves and adjudicating theologically fraught matters, mysterization goes further than that. It ought to disable courts and other civil authorities from any evaluation at all of a religious claim exactly qua religious. Mysterization removes religion altogether from the permissible ambit of civil law and policy. Now, does the mysterization of religion change the balance on the matter of conditional school funding in the question that I'm considering? I think it might, because many of the free exercise doctrines, including the ministerial exception, even certain issues involving unconstitutional conditions that are now being, at least the free exercise cluster, now championed by the court, depend upon a religious school's understanding of its own religious commitments, principles, practices, mission, and so on. So against the state's claim that a particular policy on sex and gender is neutral as to religion, the school is going to be able to more powerfully argue that actually no, to the contrary, such a policy in fact implicates the core mysteries of its religious identity and mission. Against the state's claim that sundry school staff are implicated in transmitting or carrying out the school's religious message, the school can conclusively say, actually, on our understanding of our religious mysteries, they are. Against the claim that a grant of funds conditional on the adoption of a policy of LGBT admission and hiring doesn't sufficiently interfere with the school's religious rights to render it constitutionally problematic, the school is going to be able to say, actually, we are in the only position, admissible position, to determine what our mysteries, our religious mysteries require. So in all of these ways, religious mysterization alters the calculus. It renders the free exercise cluster of rules relevant to this issue a little bit strong. It doesn't mean it's going to win, right? There are other ways for the government to get its way, but it kind of tilts the balance. Now, in the paper, I also ask a kind of separate question whether religious schools should accept funds from the government. I have some views, strong views about that matter, and strong views about the argument once made by people like James Madison and now made by a number of liberal commentators that accepting such support corrupts or tarnishes the religious organizations. I rely on some work actually by the other slightly more famous Professor Garnett to contest those claims. But I'm going to skip over that part of the paper for now and talk about the final section of the paper. Because I say, look, at first glance, am I okay on time? This conception of religion in constitutional law might seem more or less continuous with mysterization as a central feature of ancient and enduring religious traditions, including Christianity, Judaism, Islam, and others. There's a kind of parallelism in the unknowability of religion's deepest truths and realities sitting at both its theological and legal or constitutional core. But actually, mysterization in American law is different than mystery in, say, the Christian tradition. And one critical distinction involves the question of the source of the mysteries that are religion's deepest grounds. In the Christian mysteries, the source is God, the all-powerful transcendent, what's higher than the realm of ordinary human experience. And in fact, it's the division between human and divine knowledge that makes sense of mysterization. But mysterization in the American legal view of religion is different. It locates the source of the mysteries in the human psyche, in a conception of individual interiority, an autonomous choice as their ultimate source. So here we have a kind of merging of the human and the divine, and a kind of erasure of the separation that gave mysterization its sense. And so I argue that the sort of psychic interiority of contemporary mysterization illuminates two further differences, what I call the manipulability and the fractalization of religion and religious mystery. Religious mysteries are manipulable inasmuch as rather than being permanently real and fixedly true, they are impermanently real and changeably true. Religion's mysterization in American law entrenches a conception of religion in which transcendent purpose sort of collapses into the immanent, into which sort of given purpose collapses into any purpose that I might have or create or decide. The other consequence of the interiorization of religious mystery in American law is not merely fracture, but another term that I coin, fractalization, a tendency toward reduction to smaller and smaller units, or fracture upon fracture. Religious groups and hierarchies within those groups, and any sort of residual sense of differential recognition for those groups, seem to require shattering. And that inexorable movement in the legal conception of religion is toward ever more fragmentary expressions of it. The progress of individualized religion is a process of kind of involution. And religious movement, like political movement, is no longer a kind of eschatology, but a kind of archaeology. What does this mean? Well, the confluence of these factors and this conception of mysterization in American law creates a problem, I think. It's not a sustainable project, at least in the long run, in my view, in practice or in theory. In practice, at least in part because of the rising problem of the nuns, the religiously unaffiliated. And in theory, because even if the law ignores the problem of the nuns, one of my colleagues, Paul Horwitz, calls the approach good enough for government work. And that's fine, it may be good enough for government work, but eventually it's going to run into problems of incoherence, problems that itself suggest perhaps, and here I'll be provocative, the end of the time in which this right was a coherent right. I'll stop there.
Yeah. Geez, thanks a lot for that, Professor. Professor Helfand.
Just tearing up. Okay, so I guess I'm bad in cleanup. Let me start with the following. I'd never dug deeply into the unconstitutional conditions doctrine, and I found the following quote from an old article, pretty fantastic, written by Adam Cox and Adam Samaha. Quote, "You can easily question the judgment of anyone who writes a paper, even an essay, with unconstitutional conditions in the title. The topic is very 1980s, and scholars lost their enthusiasm for it not long after the Go-Go's broke up." I like that. And yet here we are, all doing it. And we're all engaged in the unconstitutional conditions doctrine, which is, I think the only thing everybody agrees on is that it's a complete and unmitigated mess. But it's back on the agenda, and it's back on the agenda as a number of the panelists, Professor Berg mentioned in particular, because of the recent trilogy of cases, Trinity Lutheran, Espinoza, Carson v. Macon, that you can no longer exclude religion and religious institutions from generally available government funding programs. And the question has been kind of what's the next stage now in this kind of ongoing, let's call it dance, between government and religion. And we've already begun to see what that might be from Maine, the state of Maine's response to Carson v. Macon. And here was their response. They amended their human rights law to say if religious schools get funding, yes, you can get funding, but you must abide by the human rights law. And if you don't get funding, then you don't need to abide by the SOGI discrimination, the sexual orientation and gender identity discrimination rules of Maine's human rights law. This is what I'll refer to as the Maine quote-unquote fix. And it means that we've moved from questions of can you exclude religion from can states now condition government funding on these sorts of anti-discrimination laws. This type of rule seems to raise questions about an unconstitutional condition, and it may be a blueprint for other government agencies, entities, states, the federal government to try to address the new landscape. You're trading religious liberty for funding. That's how we should now think about these, or maybe that's where these problems are headed. My argument in my paper is that this is a mistake. It's a mistake because there is either no or maybe very limited independent conceptual work and practical application for the unconstitutional conditions doctrine when it comes to the free exercise of religion. Let me try to explain why. So what are unconstitutional conditions? Again, it's circumstances when government provides funds in exchange for or on condition that somebody or someone relinquishes a constitutional right. The work of the unconstitutional conditions doctrine, therefore, is to figure out in what circumstances this exchange is or is not unconstitutional. Everyone seems to agree that there will be cases where it's constitutional, and there are cases where it's unconstitutional. There are lots of theories as to how this works. Mitchell Berman's emphasized the degree of coerciveness of the condition. Kathleen Sullivan has emphasized the distributive integrity of constitutional rights. Louis Fisher has talked a little bit about how it's meant to prevent the commodification of rights. Randy Kozel, and probably my favorite article on the topic, has talked about how it's meant to prevent leverage, which he defines as an attempt to prohibit, quote, government's use of an asset to extract an unrelated concession. I don't want to get into the particular theories, I just want to note what the theories are doing. They provide a theory, and the theory's goal is to differentiate when a condition is or is not constitutional. There's a theory, you apply it, and you figure out on which side of the line the condition is. Case law follows a similar format. I'll give two quick examples. In Spicer v. Randall from 1958, you had a group of honorably discharged World War II veterans, and they sought a veterans property tax exemption. California law conditioned receipt of that benefit on them signing a form that had an oath that said they would, quote, not advocate for the overthrow of the government of the United States or the state of California. And these veterans said that that condition violated their free speech rights, and the Supreme Court kind of agreed. They said it was an unconstitutional condition. Here was the logic, quote, the denial of a tax exemption for engaging in certain speech necessarily will have the effect of coercing the claimants to refrain from the prescribed speech. Note the theory again. Here the court is using coercion. Because this condition is coercive, it is now an unconstitutional condition because they have to trade in a way that is coercive a constitutional right for a certain government benefit. Let me give a different example. Here from Agency for International Development, the Alliance for Open Society International. This is from 2013. Here you had the Leadership Act, which authorized the appropriation of billions of dollars to fund NGOs who would assist in combating the spread of AIDS, HIV around the world. Here was the condition to receiving that money. Quote, no funds may be used by an organization that does not have a policy explicitly opposing prostitution and sex trafficking. The court again here in 2013 held it was unconstitutional. Why? And here's the distinction the court used. Quote, the distinction is, quote, between conditions that define the limits of the government spending program, those that specify the activities Congress wants to subsidize, and conditions that seek to leverage funding to regulate speech outside the contours of the program itself. Here you see a theory that's based on relevance or germaneness or leverage, to use Randy Kozel's phrase. Again, in each instance, you have a theory that tells us which condition is and is not constitutional. So that's how the doctrine works. And I'm trying to argue that it doesn't have application in the free exercise context. And I'd like to do that by considering the two kind of prominent free exercise frameworks, the Sherbert v. Werner, the substantial burden framework, and the Smith framework. So consider the Sherbert framework. This is kind of from Sherbert v. Werner, 1963. This is the standard that says if you have a substantial or significant or undue, depending on the formulation, burden on religious exercise, that should trigger strict scrutiny. The court itself, on a number of occasions, has described Sherbert v. Werner as an unconstitutional conditions case. Even Sherbert, the opinion itself, references the unconstitutional conditions doctrine. But I don't think it's right, given the way in which the unconstitutional conditions doctrine works, to think of this case as a case of unconstitutional conditions. Let me give you kind of the big quote from Sherbert, and let's try to unpack it a bit. From Sherbert. Quote, "Here not only is it apparent that appellant's declared ineligibility for benefits derives solely from the practice of her religion, but the pressure upon her to forgo that practice is unmistakable. The ruling forces her to choose between following the precepts of her religion and forfeiting benefits on the one hand, and abandoning one of the precepts of her religion in order to accept work on the other hand. Governmental imposition of such a choice puts the same kind of burden upon the free exercise of religion as would a fine imposed against appellant for her Saturday worship." Note how the Sherbert standard conceives of this sort of choice as not really solely an unconstitutional conditions doctrine problem, but a free exercise problem in and of itself. That's why imposing this choice is akin to, quote, "a fine imposed against appellant for her Saturday worship." Now, I have my own theory as to the internal logic of the substantial burden standard. Let's not get into it. But the point here is that it derives from the free exercise clause itself. It isn't a separate doctrine about exchanging a right for government funding. This kind of choice sounds in the free exercise clause. This is kind of obvious in some way. You can see this because the Sherbert standard is more protected than unconstitutional conditions. You don't need, whatever the theory might be, coercion or germaneness in order to trigger the substantial burden standard. You just need it to be a significant burden. And the Sherbert standard has been applied in cases that don't have anything obvious to do with unconstitutional conditions. Think about Lee, think about Yoder. Now, why is this important? It's important for the following reason. We may go back to the Sherbert standard. A number of justices have indicated they'd like to. We'll see. Fulton, will we, won't we? If we do go back to the Sherbert standard, here is the mistake we should avoid. If we think of Sherbert as an unconstitutional conditions case, what we're saying is that the reasons that make certain conditions constitutional, if we apply that and read that back into the Sherbert standard, we make those excuses or arguments available to courts in order to deem certain kinds of burdens on religion constitutional. Think what happened in Agency for International Development. There, if the condition was sufficiently germane to the funding program, then Congress could impose that kind of condition. But the substantial burden standard is more protective. And if we read the unconstitutional conditions doctrine into the substantial burden standard, we provide an argument to allow conditions that the Sherbert standard ought not allow. Separately, let me just simply say, well, will I simply say?
1 minute.
Let's find out. How many? Oh yeah, I definitely have a minute and a half. I saw how much time everybody else used. I've been watching it. Okay, good. A similar rule for this, a similar point for the Smith standard. I don't think there's any real need for the unconstitutional conditions doctrine, although there's some cases maybe we want to talk about, maybe ministerial exception cases. But again, think about what the Smith standard says. We trigger strict scrutiny when a law is not neutral or not generally applicable. So let's take the Maine fix case, right? We're going to require adherence to the Maine human rights law. Is the Maine human rights law neutral and generally applicable? If it is, then funding is not being exchanged, is not being used in exchange for relinquishing a constitutional right. Why is that? If the Maine human rights law is itself neutral and generally applicable, we're not exchanging funding for a constitutional right. There's no constitutional right at stake because it's neutral and generally applicable. And if it isn't neutral and generally applicable, well, then what do we need the unconstitutional conditions doctrine for? It's not neutral and generally applicable. We have a free exercise violation. Again, here, I don't think that the unconstitutional conditions doctrine, when it comes to free exercise, does any independent work. In sum, regardless of the standard, when it comes to free exercise, I don't think there's a need for the doctrine. Even worse, it might allow government to import arguments from the unconstitutional conditions doctrine context to justify such conditions on the free exercise that we ought not allow. Thank you.
Great, thank you. Let's hear it for all the panelists. And we have some time for questions, so floor is open. Sharif, Berg.
For Professor Helfand, does your argument against the relevance of unconstitutional conditions for free exercise imply that it's irrelevant in other areas as well? And if not, can you give us a simple example of another right where it is relevant? An example of a burden.
I think it is relevant because of the way in which rights are structured differently. Spicer v. Randall is a good one. There you have an instance where in order to gain access to a certain tax benefit, somebody had to make an oath that the court thought if you would directly regulate that, require that oath, it would violate the free speech clause. There I see that you're actually trading a constitutional right for particular funding. The reason why it doesn't, at least I think that it doesn't, it's not useful in the free exercise context is because of the way in which the rights work. Either the substantial burden standard is more protective and doesn't take kind of the unconstitutional conditions, line drawing into account, or because of the neutral and generally applicable rule, it would apply the same, I think, to whether that you had a rule that either attached to a condition or attached to the regulation itself. It doesn't seem, the doctrine, at least as it stands now, to differentiate. So I can't figure out a path where the unconstitutional, maybe except ministerial exception cases, there's something to think about there. I need to think a little more about that. But otherwise, I don't see a path to where I would ever want to use the unconstitutional conditions doctrine. I think I could accomplish all the work through the free exercise doctrine itself.
More questions? Well, while you're thinking of one, I'll ask one. And this is Professor DeGirolami, this is for you. I wonder if we were to kind of confront and embrace the ineradicability of mystery in religion, if that weighs in favor of, at least this side of heaven, using doctrine that is entirely religion blind, that is eliminating religion as a category for the purpose of talking about benefits and burdens and conditions and so on. If we think there's something about religion that we just can't get at, whether because of God or because of interiority, would our law be cleaner if we ignored it?
So that's a difficult question. I'm never sort of by instinct in favor of getting rid of law. I think the reasons that law has developed in the way that it has are themselves mysterious in some ways, and when you sort of, my instincts are anti-eerie instincts, right? I mean, when you destroy a body of law, you really can't tell just exactly what it is that you are destroying. Part of the problem that I tried to identify, and that you're gesturing toward also, I think, Rick, concerns the way that we've conceptualized religion, and whether the conceptualization of religion in law is sustainable, whether it ends up collapsing into other rights, ultimately, other interests. I suspect that it does in a variety of ways, but I can't say for certain that we would be better off if we just started analyzing religion claims simply as a matter of, let's say, speech claims or equal protection claims or something like that. I worry that the way that we've conceptualized, the court has conceptualized it, the way that we think about it ends up doing just that, but I'm uncertain about that.
Questions?
Can I ask a question?
Sure, go ahead.
Michael, can I follow up on Sharif? I would love the position that you're articulating, which is we just don't ask about unconstitutional conditions under the free exercise clause. But I'm still not sure why the free exercise clause would be different than other rights on that. What makes unconstitutional conditions not apply there? I mean, Sherbert put it that way, but that just might be the way that they put it, and it's the Warren Court, and they were a lot more fuzzy on things in 1963 and stuff. And all this other stuff has developed since then. So what's your answer to that?
And since we're going to lose people to class, solve the mystery of the Warren Court in about a minute.
I think I have 3 minutes. Yeah, I think ultimately it's because, in my paper, I'm a little bit ambivalent about this. Is it Sherbert itself that reads this way, or is it the interpretation of the Sherbert standard? I'm more confident in the latter, meaning, once we've adopted the Sherbert as, kind of read it via RIFRA, as a substantial burden standard, anytime there's a substantial burden, then it's going to be unconstitutional. I think any version of the unconstitutional conditions doctrine is going to be less protective than that standard. So you're just never going to need it. I mean, I guess we could always write the following opinions. Here's the following condition. If you want the following money, you have to do this thing that contravenes your religious commitments. That's a substantial burden on the free exercise of religion, so you have a free exercise claim, and maybe, subjected to strict scrutiny. And by the way, there's also an unconstitutional conditions claim, but, I mean, we could say that. What's the use? I just don't see why. I think maybe there's an answer in here that maybe we don't subject unconstitutional conditions claims to strict scrutiny. I don't think that's true, though. So I just don't see what the case would be where the unconstitutional conditions doctrine would do any work, unless, you had an insubstantial burden on religious exercise, and it didn't satisfy the substantial burden standard, but you thought it could satisfy the unconstitutional conditions standard. That seems rough if we use a coercion standard, or if you use Randy Kozel's leverage view. Maybe there's a case in there. I'm just struggling to find it. I'm open to a hypo.
So just a quick thought on maybe why free exercise might be different, and why we might, that's kind of the deep logic of the religion clauses, we might want more protection and not have the unconstitutional conditions thing. And that is that the religion clauses are really about getting government out of the religious lives of the people in a kind of full-fledged way, and that the unconstitutional conditions doctrine allows all sorts of ways in which government can deeply affect you by how it characterizes the program. The problem is, I think that's a stronger argument if you also have a strong establishment clause that is getting the government out of the religious lives of the people on that side. And unfortunately, this court is less committed to the establishment clause.
Well, let's continue that conversation, even though what Tom just said is wrong, in the next panel. Thanks very much.
Welcome, everybody. Welcome back. I'm Professor Nicole Garnett, and I'm delighted to be here. I want to congratulate the Law Review and the Religious Liberty Initiative on a really terrific lineup on a very, very important topic that is undoubtedly going to become even more important. My research focuses in particular on education, and I think after Karsten, the questions about unconstitutional conditions are the next big questions in the parental choice movement, just to give one example. I am going to introduce the panelists today and keep my introductions very brief. I'll ask each panelist to talk about 8 minutes, and so we'll have time for questions at the end. First is our very own Lloyd Meyer, a professor here at the University of Notre Dame Law School. He is a graduate of Stanford University, or I see we overlapped by 1 year, and from Yale Law School, where we overlapped by 2 years. And then he clerked for the Judge Lowell Reed on the United States District Court for the Eastern District of Pennsylvania, and practiced tax law at Kaplan and Drysdale. His research interests and expertise include advocacy by nonprofit organizations, the intersection of election law and tax law, with respect to lobbying and other political activity, federal and state regulation of nonprofits, including churches and other religious organizations, and the role of nonprofits both domestically and internationally. Next up, Professor Michael Moreland is the University Professor of Law and Religion and Director of the Eleanor H. McCullen Center for Law, Religion, and Public Policy at Villanova. Do you have an acronym? That'd be really fun. You need an acronym. He received his undergraduate degree in philosophy from Notre Dame, a master's degree and a PhD in theological ethics from Boston College. We'll forgive him for that. And his JD from Michigan Law, we might forgive him for that. After graduating, he clerked for Judge Paul Kelly on the 10th Circuit and practiced as an associate at Williams & Connolly. Before joining the academy, he also served as associate director for domestic policy at the White House under President George W. Bush. His scholarship focuses on constitutional law, torts, bioethics, and religious freedom. Lucia Silecchia is a professor of law and associate dean for faculty research at the Catholic University Columbus School of Law. She graduated from Queens College, CUNY, and have received her JD from Yale Law School. She has written broadly in the areas environmental law and ethics, elder law, Catholic social thought, legal education, law and literature, and legal writing. And finally, Asma Uddin is the author of When Islam is Not a Religion, Inside America's Fight for Religious Freedom and the Politics of Vulnerability, How to Heal Muslim-Christian Relations in a Post-Christian America. She was formerly legal counsel at the Becket Fund for Religious Liberty and has held academic fellowships at Georgetown and UCLA. She is currently a visiting assistant professor at Catholic University School of Law. She's a graduate of the University of Chicago Law School. So we're going to go down the line in alphabetical order, starting with Professor Meyer. I just told him I wasn't going to mispronounce his name, and I did.
That's all right. This is a football player I can be associated with now. So my thanks to the Notre Dame Law Review, and particularly Nicholas, Laura, and Courtney, and to the Notre Dame's Religious Liberty Initiative for the opportunity to speak at this important symposium. So I'm going to focus my comments on the consequences of unconstitutional conditions for religious organizations in the context of tax law. More specifically, I'm going to consider whether tax law is different in that conditions on tax benefits are less likely to be considered unconstitutional than government benefits in other contexts. In contrast to Tom Berg's two categories that was mentioned in the first panel, I divide the conditions imposed on tax benefits provided to religious organizations into three categories based on their relationship to tax law. This also goes beyond the draft paper that my fellow presenters have seen, including the moderator, as my thinking is developed thanks to the insights of their draft papers. So two of these categories, I believe, are generally constitutional because of their close relationship to either specific tax law provisions relating to those conditions or more general tax principles. Now, the third category is generally not constitutional because it lacks either of those relationships. I believe this is a little more permissive for the government than it is in other legal contexts, as I'll explain. So the first category are conditions that help define the government program that Congress is seeking to support providing those benefits. As mentioned by Michael Helfand in the earlier panel, in Agency for International Development versus Alliance for an Open Society International, the Supreme Court clarified that in the free speech context at least, Congress may place a condition that helps define a program, even if that condition creates a burden on a constitutional right. As Michael Moreland is going to discuss, such conditions are considered as germane to the program at issue, oversimplifying. The court concluded with the idea of a program, an activity or set of activities that are supported by tax benefits, in case you're wondering, well, how can this be a program? Because the court said it was. So two examples of this type of conditions are the prohibition on private inurement and private benefit, which is imposed on all tax-exempt charities, including religious organizations, and the prohibition on having a significant purpose or activities that are contrary to fundamental public policy, also imposed on all tax-exempt charities, and that's based on an interpretation of Internal Revenue Code Section 501c3 that was endorsed by the Supreme Court in the well-known Bob Jones University versus United States case. In that case, the court held that what Congress intended in creating Section 501c3 was that it was only to apply to organizations that were charitable in the common law sense, which included that they could not work against whatever a fundamental public policy might exactly be. In that case, it was race discrimination in education that they found was problematic. The second category are conditions that place certain specific activities outside of the supported program, and so require those activities to be done without tax-provided support. The primary example of this kind of condition are the prohibitions that, again, all charities, particularly religious organizations, face on political campaign intervention and limits on their lobbying. The Supreme Court upheld the substantial lobbying prohibition against a free speech challenge in Regan versus Taxation Representation, and 2 federal appellate courts have upheld the political campaign intervention prohibition as against religious organizations and against free exercise challenges, basically following the reasoning that was used in Regan versus Taxation Representation. Now, an important aspect of these decisions was the fact that the Supreme Court and the lower courts held that an organization that wants to engage in the prohibited specific activity can still do so, just not with tax benefits. How does it do that? It creates a closely related affiliate. And that affiliate cannot be a charity. It has to give up some of the tax benefits, but in exchange, it gets to do the prohibited activity. I should note that these decisions fit into a larger context, which is in the era when the Supreme Court was applying Sherbert versus Werner, that is applying strict scrutiny to burdens on free exercise of religion, it consistently rejected claims of free exercise for getting out of tax laws. And the argument basically the court adopted was that ensuring a uniform tax system was essentially a compelling governmental interest, and the least restrictive or narrowly tailored way of ensuring that that interest was served was not allow even free exercise-based exceptions to sort of multiply to the tax laws. I think this is particularly important in the context of the political activity restrictions because the tax law generally denies deductibility for funding political activity, whether it's campaign work or lobbying. And if you could give to a charity, including a religious organization, let's say even with religiously motivated political activity, then the donor could get a deduction by giving to that charity. The charity could fund the political activity, and you now create, what's commonly known in tax law as a loophole that people can take advantage of. The third and final category of conditions tied to tax benefits are neither particularly germane to the scope of what Congress sought to support, nor are distinct activities that you can just move to an affiliated entity. So these conditions are contrary, I would argue, just what permeates some legislation as a core mystery, as Marc DeGirolami phrased it, or centrality, as Tom Berg mentioned, or central importance, as Elizabeth Clark discussed in the earlier panel. So one example of this would be if Congress sought to impose a condition on charities to say if you want to enjoy the charitable benefits, you can't discriminate on the basis of sexual orientation. Now, I'm assuming that discriminating on the basis of sexual orientation is not a fundamental public policy prohibiting that discrimination, which I think is unlikely as in the foreseeable future it will rise to that level. Another example would be, and this is the imposition of Title IX requirements in religious schools, even when those requirements contradict the practices of schools adopted for religiously motivated reasons. Now, this is not purely a hypothetical, actually. There are 2 federal district courts that recently decided that religious schools are subject to Title IX because they receive federal financial assistance in the form of the tax benefits they enjoy under the tax code. And without knowing much about Title IX, I'd argue the first line of attack on those decisions is no, tax benefits don't equal federal financial assistance. But if that fails, I would also argue that, and that's an unconstitutional condition to sort of try to leverage, as Randy Kozel has written about, the tax benefits to impose, to sort of shoehorn Title IX onto these religious schools. One last note, I'm not sure my analysis changes, even as Michael Helfand suggests. The unconstitutional conditions doctrine does not add anything to free exercise analysis. That's because the government, as I've already suggested, has arguably has a compelling interest in ensuring a uniform tax system, and narrow-tailoring means the government can prohibit even free exercise-based exceptions when those exceptions would undermine the uniformity of the tax system. And instead can require either that the religious organization give up tax-exempt status, as happened to Bob Jones University, or establish an affiliate that doesn't enjoy those tax benefits to engage in the prohibited activity. Thank you for your attention. I look forward to the discussion.
Well, thank you to the Law Review editors for the invitation to participate in this program, and to my friends on the panel here. In some ways, my paper is something of a doctrinal rejoinder to Michael Helfand's comments, because I do think that there's more that we can glean from the doctrine of unconstitutional conditions as applied to free exercise than maybe he suggested. I began by noting, I suppose somewhat churlishly, though, that for a symposium on the doctrine of unconstitutional conditions in religious free exercise, the problem is that there actually isn't much doctrine. That the leading casebook in the field, I suspect Professor Berg won't dispute this, the one that he edits, has only 3 mentions of unconstitutional conditions, each in a passing note about Sherbert versus Werner, which, as Michael Helfand pointed out, is somewhat peculiarly an unconstitutional conditions case, and then the line of cases from Trinity Lutheran to Carson is also an unconstitutional conditions problem. But what I want to suggest is that as we more and more see these kinds of issues arising with funding, with strings attached and different kinds of benefits to religious institutions that have been opened up by the Trinity Lutheran to Comer line of cases, that this issue of unconstitutional conditions will, I think, become more prominent. And that in a kind of exercise of symmetry across the First Amendment, we can look next door to the free speech clause in the way in which there has for 70 years or so, but especially the last 40, there's been a robust set of doctrinal tests that have been developed with regard to what constitutes unconstitutional conditions in the free speech context. And I should add that there's, working in the background here, there's now I think a pretty clear rejection of an older view that maybe had some traction, which was that there really isn't much of an unconstitutional conditions problem with regard to the First Amendment because the government doesn't have to provide the benefit at all. The government always has the choice whether to provide a benefit, and to the extent that they can do so, they can condition that benefit however they might want to. And Kathleen Sullivan, in her classic article on unconstitutional conditions from the Harvard Law Review, kind of says that this greater includes the lesser view would basically obviate the whole question of unconstitutional conditions, but that I think it's fair to say that that hasn't won the day, and that the court has consistently now, I think, in a line of cases said that that there is a problem when, even if the government could withhold the benefit altogether, it conditions it in one way or another. And so for part of the paper, what I talk about is, so what is this kind of body of First Amendment law in which these tests have been developed? And mentioned Regan versus taxation without representation, which was a restriction on lobbying activities, which I think, in line with what Professor Mayer said, I do think that it has there's a kind of peculiarity there to the tax code, and particularly to lobbying activities. And importantly, also, as picked up in later cases, a line that the court adopts in Regan, that the availability of setting up an affiliate or a parallel set of programs to do that which you want to do but wouldn't be able to do if you complied with the government's condition, that's a relevant consideration in a lot of these kinds of cases. And I think in the religious free exercise context actually cuts in favor often of the religious institutions, because unlike taxation with representation, which could just spin off a 501c4 organization to do its lobbying, it's much more difficult in the context of, say, a social service agency, a hospital, or a school. I mentioned that a case actually that hasn't come up yet today, but I think is very centrally important to this area and highly controversially, Russ versus Sullivan, which is probably the high watermark of the government's ability to set conditions in some respects. This is the case involving restrictions on Title X funding for family planning programs. One of the things that an incoming administration does on January 20th of whenever a new president's inaugurated is, depending on which side of the issue they're on, they revise the Title X rules to comply with their side on that particular question about whether or not family planning grant recipients can be restricted from counseling, referring, or engaging in abortion-related activities. And in Chief Justice Rehnquist's opinion for the court in Russ versus Sullivan, he says, well, you know, here it's just the fact that the government is regulating the program itself. It's not regulating an entity. I think that's another abiding distinction that you see in the doctrine. It's one thing for the government to say, we'll fund this. The government can favor, as he says in Russ versus Sullivan, childbirth over abortion. It can take a particular viewpoint with regard to what kinds of things it will fund. But it would be another thing if it then tried to regulate outside that program to the entity more generally, so that the entity, the doctor, the clinic, whatever, that's receiving the Title X funding has to abide by those restrictions when they're in force, but it can, again, either set up affiliate institutions or it can, outside the scope of the Title X funding, engage in abortion-related activity. And so Regan and Rust, I think, kind of mark the pole of, if you will, the government's ability to set conditions. But the last few years have been much more strongly, I'd suggest, in favor of limitations on that. And in particular, in cases, in some ways it goes back to a case called FCC versus League of Women Voters. This was a condition that PBS stations or other public broadcasting stations that received money from the Corporation for Public Broadcasting could not engage in any editorializing activities. And the concern there that it would be difficult for them to set up an affiliate to engage in editorializing activities, and that there was a kind of mismatch between what in some instances were very small contributions by the Corporation for Public Broadcasting to these stations, could just be 1 or 2%, with an overall ban and prohibition on any editorializing activities. I think that same kind of strong free speech norm was picked up again by the court in Legal Services Corporation, Velasquez case, where there was a prohibition on LSE grant recipients from engaging in litigation that tried to change the welfare laws. Basically, they could take clients that were denied welfare benefits if they were erroneously denied, but they couldn't engage in litigation to argue for overall reform of the welfare laws. And in that case, once again, the court said that there's this leveraging problem, which has been a consistent theme for the last several minutes, but also that in that context as well, there was an effort to regulate the speech of the participants in the program, the kinds of representations that they could take on, and that in the court's view, all of this posed a serious First Amendment free speech problem. And then AID has come up a few times already, starting with Michael Helfand's paper, but I think that that really does now kind of set the template for the approach to these questions, and in particular, when we talk about germaneness, which is the kind of overall theme of my paper, I draw that from Kathleen Sullivan's article, but I want to expand on the definition that she gives, because I think germaneness is both about a kind of purposeful or conceptual link between the reasons why the government is providing funding and the kinds of things that it wants to fund, but also this distinction that the Chief Justice Roberts makes in AID with regulating inside a program and then trying to regulate outside the contours of the program. And that when the government tries to regulate outside the contours of the program by affecting the message and the speech of the recipients of the grants in that circumstance with regard to decriminalization of prostitution and so forth, that all poses a First Amendment violation in an unconstitutional condition. So how would this cash out in the religious free exercise context? I mentioned 3 hypotheticals, or actually not so hypotheticals, as these issues are evolving. One is the post-Carson Maine requirement that recipients of its scholarship funds, that shout out to the Religious Freedom Initiative, was helpful in filing an amicus brief in that case. One is with regard to employment practices of those schools. Second would be restrictions or impositions on religiously affiliated hospitals that receive Medicare and Medicaid funding with regard to what kinds of services they must provide. And then third, and this has been a recurring fight for the last couple decades or so, are charitable choice rules with regard to social service agencies that receive government funding and what kinds of both employment, but also then kind of their selection of clients that they serve. In all of those instances, but I acknowledge that as the Chief Justice Roberts says in AID, this line of inside and outside the program, this germaneness line, is sometimes difficult to apply. But in all those instances, I would argue that those would all be unconstitutional conditions. Those would all be trying to leverage the government's funding with regard to the contours of a program outside the program to require that either messages or employment practices or hospital procedures be undertaken that the religious institution has sincere objections to. And so that's my provisional conclusion with regard to where I think some of this doctrine is heading, and why I do think that cases like AID can provide us with a set of kind of doctrinal traction in this area, notwithstanding Michael Helfand's concerns that in some ways maybe it's not doing any extra conceptual work in the first place. So thank you.
Thank you, Michael.
Thank you. And first I want to thank the editors of the Notre Dame Law Review. Not only has this been a fascinating discussion, and I'm jealous of students who get to think these ideas, but also you've been wonderfully hospitable, and so I say thank you. My paper is slightly different in that I am anticipating a problem and asking the question about what might our doctrines on benefits unconstitutional conditions have to say for a problem that I hope won't arise, but I am fearful about it. So let me give a little background about the question that I'm asking, but really what this is an invitation to think with me what this might mean in the future. So the question that I want to ask is whether or not in the future we could be facing questions about unconstitutional conditions in the context of the growing increase in the number of states allowing assisted suicide and what that might mean for the conditions imposed on individuals or institutions involved in the healthcare industry. And there are some who say that this is not a question that we have to get to now, that it is premature for at least 3 reasons. One is that anytime a state passes a statute authorizing assisted suicide, there are provisions in there to protect conscience, and they get a lot of attention. And I think the public perception is, of course, we would not involve or require the involvement of a person as an individual or an institution in that activity. And I would argue that those provisions are inadequate. Second, there are some federal statutes that do include protections against forced involvement in this, so that might go a long way in affording protection. And then finally, of course, there's been no established constitutional right to die, so in that sense, it might be a while before we see arguments indicating that to protect institutions and individuals runs into conflict with another constitutional protection. And yet I do think there's a value in thinking this through now before that actually becomes a pressing issue. One is that studies show that public support for assisted suicide is growing steadily. Second, the number of states allowing it has increased, and there are a number seriously considering it now. And then third, litigation to expand the scope is increasing here in the United States. And when we look international, the trajectory, unfortunately, seems to be only in one direction, and that is expanding the scope. And so my hope is to think prospectively about what might be done to afford protections in the event that that comes to a head. And I think that's important because medical advances often do outpace the ethical considerations of it. Many medical issues like this one are those that might be incapable of compromise. And then third, and maybe most importantly, many of our medical institutions were founded by religious organizations, or they attract people who see the pursuit of medicine as a vocation, and they want it to be informed by their religious views. And then, of course, as we know, federal funding pays for a significant amount of medical care in the United States. Currently, when it comes to debates about conscience protection and medical care, many of those debates have focused on abortion, on contraception, and then more recently, matters relating to gender identity. And so the assisted suicide context has not been front and center, but I think there are some things that we can learn about that. Just by way of background, assisted suicide is now legal in 12 jurisdictions, 10 states that have passed this either by statute or referendum, the District of Columbia, as well as Montana, which has authorized it by judicial decree. So the first thing that I'd like to address is why current conscience protections in state statutes are, I think, woefully deficient and therefore should not be something that we could rely on in the future. And the first reason for that is when we take a look at conscience protections currently provided by the state, when it comes to individuals, one of the deficiencies in those statutes is that they don't tell us with any clarity which individuals will be protected. And I think most people today will say, well, of course that protects doctors. Of course it might protect nurses. But what about pharmacists? Do we use the abortion analogy when we look at conditions for a pharmacist license? What about nursing assistants? What about nursing aides? What about other administrators in hospitals? And so the Washington statute, which is one of the prototypes, says, for example, only willing healthcare providers shall participate, but we don't really know with certainty who those willing healthcare providers are and how expansive that might be. In addition, many statutes, the ones that are based in Oregon, say that the healthcare provider shall transfer upon request a copy of the patient's relevant medical records to a new healthcare provider. And that seems like a passive request. I think patients have a right to their own healthcare records, but there are other statutes that would seem to embed in that a requirement for a referral. And it seems to me that that's a question that could become more important in the future. Is that a forced involvement that might constitute material cooperation with an intrinsic evil? And if that's the case, can a doctor refrain from even giving a referral, or could that be required as part of their licensing requirement? In addition, I worry that the institutional protections are quite weak in many of these statutes. So, for example, when we're taking a look at the Oregon statute on an institution, and so here I'm thinking of a religiously affiliated hospital or nursing home, the typical Oregon statute says that an institution may prohibit another healthcare provider, so doctor, nurse, from engaging in assisted suicide-related activities on the premises of the prohibiting provider if the prohibiting provider has notified the healthcare provider of the prohibiting provider's policy. So that might suggest if I go to work in a Catholic hospital, they can tell me that as a condition of my employment, if they notify me that I cannot engage in that activity on their premises, I can be barred. But I think this imposes two limits on the ability of that religious hospital to really proclaim its view about the sanctity of life. First, the premises clause limits the ability of the healthcare institution to control whether or not their employees will engage in this activity off-site. And so in theory, I could be employed by a religiously affiliated hospital, but then off-site fully engage in an activity that the institution sees as morally wrong, and this doesn't seem to provide any protection for the institution to say, we do not want doctors who engage in this on our staff. The other thing that this allows physicians and patients to do is to enter into a private contract, not involving the religious institution, to engage in this conduct off premises. And again, I'm not sure that that provides enough of an ability for the institution to assert itself. So I think the state provisions are inadequate. On the federal level, we have some provisions that right now at least give me some comfort. For example, right after Oregon passed its statute, there was a provision saying that no federal funds would be used for this. The Affordable Care Act also includes a provision that seems to protect conscience. But as I look ahead, I'm worried. And so what I'm trying to think about is, as we look forward, how can we prospectively ensure that involvement in this does not become the basis of an unconstitutional condition? My colleague, Mark Rienzi, he proposed that under the 5th and 14th Amendment due process clauses protect somebody from being forced to engage in this. So I wonder, is that enough to provide reliable protection? Another commentator proposed the use of the ministerial exception to allow an institution to make a very bold statement about what its employers and employees might do. To what extent does advance notification eliminate any concern about depriving patients of a range of services? Who should this protect? And then I think a final question, and to me the most interesting one, in this question about unconstitutional conditions is the question of material cooperation. And if we're developing a doctrine in this area, how far does it expand? How attenuated is my involvement before I'm entitled to protection? And who gets to decide? So I'm hoping for your feedback, your thoughts about how we might, again, prospectively try to address this problem before it comes to a head as it has in other areas. So thank you.
Great, thank you. Thank you to Notre Dame and to the Law Review for having me here today. So in my paper, I'm looking at government conditions on religious child welfare organizations that work with the state to provide these services. And in it, I consider some of the cases that have arisen in this context, or there are very few cases that have arisen. And then I just have some very preliminary reflections on some of the arguments raised there and the opinions that courts have issued. So just to kind of lay out how the system works and when it comes to child welfare, there are two options for prospective parents seeking to adopt children. In the private system, birth parents voluntarily place their child up for adoption through a private organization. In contrast, the public system includes children that have been removed from their families by the state, or they've been orphaned without any relative to take care of them. And private organizations, including private religious organizations, can work in the public system, and in many cases have partaken in this work, so much so that in some states, Christian child welfare organizations are the primary provider of state child welfare services. Of course, participating in the public system means that these private organizations have to work quite closely with the state, and many of these private organizations rely on contracts to govern their relationships with the state, essentially making them state contractors. Some states require compliance with their non-discrimination policy as a condition of receiving those contracts, even if the non-discrimination policy runs counter to the religious organization's sincerely held religious beliefs. And so the question then arises as to how to balance the organization's right to engage in religious exercise with the state's interest in non-discrimination. The Supreme Court recently considered this question in Fulton v. City of Philadelphia. In Fulton, the City of Philadelphia refused to contract with Catholic Social Services, or CSS, for the provision of foster care services unless CSS agreed to certify same-sex couples as foster parents. CSS did not comply with this requirement and instead challenged Philadelphia's public accommodations law under the First Amendment and specifically argued that the Smith standard was not applicable there because the city's policy permitted individualized exemptions. And the court agreed with this and focused on a contract provision that allowed the commissioner of the city's Department of Human Services to grant exemptions in her sole discretion, and said that this afforded sufficient discretion to the government to render the policy not generally applicable. And so Smith wasn't applicable there, and the strict scrutiny was applied, and CSS won. And by focusing on this narrow question of general applicability, however, the court sort of sidestepped a sort of bigger issue, how exactly to balance religious liberty and LGBTQ rights in the context of religious child welfare organizations. And so the area remains open to legal uncertainty. A few states have taken steps to create certainty in this space. 11 states have enacted religious exemptions to protect these religious organizations. The exemptions are not identical, but generally they sort of prohibit the government from punishing the religious organization and also prohibit the government from denying these religious entities licenses, grants, contracts, or the ability to participate in state programs based on their religious beliefs. There are very few lawsuits in the space. In states with religious exemptions, same-sex couples and others have challenged the exemption as unconstitutional, generally alleging establishment and equal protection violations. For example, in the Michigan case, Buck v. Gordon, the religious agency St. Vincent brought suit after the state settled with a same-sex couple in an earlier case, Dumont v. Lyon. And in states without exemptions, there have been two notable cases. One is the Blaze case out of the state of Washington, where a religious couple that had been denied a foster care license sued under the Free Exercise Clause. And there was another case involving the New Hope Religious Adoption Agency in the state of New York that was told that if it did not comply with the state's non-discrimination policy, the state would shut it down. The New Hope case is sort of fascinating because it's entirely privately funded. So there's no question of sort of government funding here, but it would essentially be denied the ability to operate at all if it failed to comply with non-discrimination policy. So in reflecting on these cases in which Again, they're few in number, but the religious agency has ultimately prevailed. And these cases are, again, the New Hope case in New York, Buck v. Gordon in Michigan, and the Blaze case in the state of Washington. And in each of these cases, the court found that the laws at issue were not neutral nor generally applicable. On general applicability, even without Fulton's guidance, I mean, some of these sort of timelines span before, after, during Fulton, but in each case, the court found clear evidence of government discretion. For example, in the Blaze case, the state actually asked prospective foster parents to fill out a questionnaire asking how they would treat their children if they would come out as LGBTQ. Specifically, they asked whether the parents would be open to hormone treatments if the children were experiencing gender dysphoria. And so it was kind of like very obvious that the government had discretion to reject applicants, which it did always, if they answer the questionnaire saying that they wouldn't offer these hormone treatments or permit them. On the question of neutrality, that's really what I was sort of reflecting on. In some cases, it's really, again, very obvious. In Buck v. Gordon, you had a case where the Attorney General made very public hostile statements against the religious adoption agency, calling them hate mongers and people who just dislike gay people more than they care about the need of foster care kids. But even in the absence of very clear governmental statements like that, the courts have consistently recognized a lack of neutrality. In the Blaze case, again, that's the one that dealt with the questionnaire. The court said that the questionnaire, quote, infringed upon or restricted practices because of their religious motivation. But more interestingly is the sort of recital of the long history of these adoption agencies in providing these services. In the New Hope case, for example, so in that case, the district court had dismissed the complaint for failure to state a claim, but the appellate court reversed and remanded, holding that, quote, a matter bearing on religious hostility and making dismissal premature is a severity of the state's actions in ordering New Hope's closure. It is plainly a serious step to order an authorized adoption agency such as New Hope, operating without complaint for 50 years, taking no government funding, successfully placing approximately 1,000 children, and with adoptions pending or being supervised, to close all of its adoption operations. All the more serious when the agency has, for 5 years and without objection by the state, used recusal and referral to avoid rejecting applicants on the basis of its religious beliefs. A court properly starts by asking what authority the state has had to order such a shutdown and what procedures attend such a decision. And sort of these recital of these sorts of facts, I've noticed, kind of shows up consistently across these cases. The long history of the religious child welfare organizations serving their communities, the thousands of successful placements, and the fact that the state had no objection to limiting placement to married heterosexual couples until very recently. For example, in the New Hope case, the court noted that until 2010, the state's policy on placement matched New Hope's requirement of a married heterosexual couple. So in other words, there's sort of this idea that there's been a long-standing and successful practice that only recently became problematic, and the problematization feels artificial to the courts. In Buck v. Gordon, the court gets at this artificiality when it notes, St. Vincent places its children with any certified parent, unmarried couples, same-sex couples, or otherwise. This is precisely the non-discriminatory conduct the state desires. The state still wanted to cancel St. Vincent's contract belied the true purpose of its actions, to stamp out St. Vincent's religious belief and replace it with the state's own. The court also points to St. Vincent's history of affirmatively referring same-sex couples seeking assistance to other agencies. The state's insistence on excluding St. Vincent's despite this practice of referral, quote, strongly suggests that something else, namely religious targeting, is the state's real purpose. Now, this question of the history, the sort of long history of successful placement comes up with regard to many different aspects of these cases. For example, in cases where the challengers are, where there are people challenging a religious exemption have argued that this history kind of points to an unconstitutional delegation of government power to religious actors. In Fulton, there was a lot there about how historically religious actors were in this space and have been doing this work long before the government got involved. And then in one case, in Buck v. Gordon, the adoption agency actually asked the court to apply the historical test under the Establishment Clause because of a long history of religious organizations serving in this space. But what's intriguing to me is the way that this history kind of gets at this question or points to the artificiality of the government's conditions. And so I was reflecting on this in relation to this point about germaneness. This idea of a government condition being constitutional if it's germane to the program and unconstitutional if it's not germane, right? And so Michael was Professor Moreland was getting at this point as sort of just demarcating the inside and outside of a government program. The government can place conditions on what's inside the program, but it cannot go outside the scope of the program and infringe unconstitutional rights. And so just sort of reflecting on that, this idea of religious child welfare organizations working in a space for a long time, being very successful, not having created impediments to the government's purposes. These all seem to sort of point to this idea of where exactly we might draw the line in terms of what is inside the program and what is outside of it, what is germane and what is kind of random. And of course, understanding that this idea of practical long-standing success has its limits, not very different from what a court might hold when applying the compelling interest test. And this ties in as well on the question of germaneness as sort of an analog to the tiers of scrutiny. And so in the child welfare context, if instead of success there is a real impediment to access, or if the religious actors believe significantly limited the placement of children, then I think the government conditions would likely be considered germane and therefore constitutional. Thank you.
So we have about 15 minutes for questions. I'm going to take the moderator's prerogative and ask a question to start. It's a little not directly relevant to necessarily the papers, but the topic of this panel is the consequences of unconstitutional conditions. And it strikes me that one consequence of conditions, unconstitutional or not, is skittishness among people private religious entities in particular, who may cooperate with the government to provide services and public goods that if they get worried about conditions, they may withdraw from such cooperation. I think Maine is an example. Maine imposing its non-discrimination requirements after Carson meant, as far as I know, I don't think any religious schools chose to participate in the program. There's some evidence in some of the, so I'm a school choice person, so school choice is on the rise. We have at least 2 states with universal choice, several others that are up about 80% eligibility. And we have to have really good schools participating in these programs or they won't work, right? We have to engage the religious sector, or hospitals is the same thing, child welfare services. So I actually was thinking as you were talking about program design, particularly in education context, but is there a way to, I talk to Catholic bishops sometimes and they are nervous. We don't know if we want the government money. We don't know if we want to do this. They're going to come after us. Is there a way to think about designing programs to minimize unconstitutional conditions? So for example, if you have different mechanisms, so and the choice mechanism might be a voucher, which a publicly funded scholarship versus a tax credit, versus another new one is the education savings account where everybody gets $7,000 and can spend it however they want. Are some of these things are more likely, unconstitutional conditions, challenges, more likely to succeed depending upon program design? Is there a way to sort of maximize the freedom at the front end when you're designing a program to minimize what I really do have a fear of, which is that these schools and social service providers will just not participate, and that will not be good for society?
Yes, right. No, and a lot of this, of course, would depend on the particularities of it. Obviously, I took a pretty strong view that I think that the entities have a going argument, but that requires litigation. It requires, fighting what could be politically unpopular fights within a state like Maine. So I think they have some constitutional arguments on their side, but I think you're absolutely right, and it's an interesting phenomenon. We were at a conference some years ago about sort of Catholic education in the international sphere, and the way in which, for a long time, in many parts of the world, you have funding of religious schools, but with lots and lots of strings, and that's not seen as as a problem on either side. And in the United States, private schools, Catholic schools included, have tended to be free of these government restrictions, but they've also not had much funding. And so now as that boundary becomes more permeable, I think that the things that Professor Garnett raises about program design, I mean, for my money, the freer the better in terms of allowing schools within whatever the outer limit would be to design their programs as they wish, but in a lot of states that will not be a popular option.
Any comments from or questions from panelists to one another before I open it up to the?
Just to pick up on Asma's paper, having lived outside Philadelphia and following the Fulton case, it was interesting the way in which that point about how Catholic social services or forerunner organizations had been involved in foster care for well before the state of Pennsylvania took over foster care services. And the extent to which, I mean, your paper points out this, I think, nicely, the extent to which is that kind of an optical point that, you know, that basically religious institutions were doing all this good charitable work and then the government took it over and started imposing conditions on it? Or what, if any, are the kind of doctrinal what's the doctrinal significance of that? So.
Well, I argue that this kind of points to this question of like where to draw the boundaries. I mean, I think in a lot of those cases it was kind of being used as an optical element, but in sort of reflecting on in relation to your points about germaneness, it occurred to me that it could be used in a more sort of doctrinal way.
So I have a question for my fellow panelists, and this came up in at least I think briefly in the first panel, which is some conditions can be seen as religious targeting. I think that was mentioned. You know, so the classic one here is that if you have a policy against same-sex sexual orientation discrimination, that's probably only going to affect it. I think maybe Tom Berg said in his paper, you know, will only affect religiously motivated groups. That secular groups wouldn't discriminate on that basis, so they wouldn't be subject to it. And even some religious groups obviously wouldn't, depending on their doctrine. But there would be a targeted set of religious groups, and that makes that condition particularly problematic from a constitutional perspective. But I'd be curious if my panelists agree that that's right, that those conditions are the ones that particularly are vulnerable here. And implicitly, does that mean that conditions that are not, like racial discrimination education, Bob Jones, was not limited to religious schools by any stretch of the imagination? And so, you know, is that sort of condition less vulnerable because it applies to some secular entities as well, and so it's not targeting a set of religious beliefs?
So I think in the context I was looking at, I think right now, it is not just religious organizations that share that viewpoint. So the American Medical Association, for example, right now is fully on board with protecting the conscience of doctors and speaking about how this is contrary to the model of medicine. So I think right now, it is religious groups that will say, morally, we can't do this. But I think there are also others who will say, for secular reasons, this is not what a physician would do, or this is not part of our tradition. So I think right now, there may well be individuals, perhaps not institutions, that have that opposition for reasons unrelated to religion. So I think right now it's different, but I don't know if that's going to change. And there are people who will say, as the professional landscape changes, the law should change with it and see this only as a religious issue. So I don't think we're there yet, but I do think with time, if an issue becomes more identified with particular religious groups, I think that's where more of the problem is going to come up.
Yeah, I mean, I think that's a good point. And New Hope, for example, the court pointing out that the state's policy about placing children with married, specifically married, but married heterosexual couples, was the policy right up until very recently. So it suggests that there would be secular groups that would also, have that type of perspective. But I think Lucia's point is really interesting, that there's so much outside of in this sort of broader landscape that's shifting, that maybe religious organizations are going to be the only ones kind of holding on to that particular belief.
Professor Gerges.
This is a question for Mike that picks up on Lloyd's. So I took you to be saying that even if a law is neutral generally applicable, you could get a religious free exercise claim against it on the unconstitutional conditions doctrine. That seems to have the odd implication that the very same requirement of a religious organization will trigger a constitutional claim if it's only about withdrawing a government benefit, but not if it involves criminal or civil penalties. Is that true? And do you think that's odd?
Yeah, I appreciate the asymmetry there. I guess the question is whether or not there are, when the government seeks to impose those kinds of strings, whether or not that, even if it, like I say, if they're regulating outside the program, right? If they're under the relevant sense of AID, if they're regulating outside the scope of the program, that would pose the kind of unconstitutional conditions problem if you draw the analogy across speech to religion. But say again about criminal and civil.
Well, I was just thinking, if we keep the Smith rule, then a criminal or civil penalty attached to violating the requirement doesn't trigger any kind of constitutional protection because it's general and neutral, and that's the end of the story. But if it's a condition of granting a government benefit, you're saying it does come under the separate constitutional protection for, against unconstitutional conditions. That seems odd because then, like, I'm better off as a claimant if the thing was only a condition on government benefit than I would be if the thing was a trigger for criminal penalties.
Right, and I guess that would go back to the leveraging point, right? Is that's the underlying concern in this area with speech, and I think it's translatable over to religion, that that we worry about the government being able to use its vast regulatory and spending power to leverage certain requirements that, right, if it were just to do so in a way that was generally neutral and generally applicable, if Smith were still the prevailing standard, it wouldn't trigger a constitutional problem.
Yeah, the difference, sorry, the last thing. The difference, I guess, with free speech, if you're right against Michael's argument, is that there's nothing like a Smith rule for speech. Right. So we are talking about something that would be a constitutional problem if the incidental burden were the same weight that was incidental to a criminal or civil penalty.
Right.
The statute.
Right.
So, that seems to lend some credence to his argument that unless we've independently identified a constitutional problem, the unconstitutional conditions doctrine will be triggered. So that's going to be rare in free exercise
because of Smith, right?
Tom?
I guess it's either comes up under if the ungermane condition makes it a substantial burden, or whether a substantial burden is unlawful. This is a question for Professor Meyer. What's to stop a state or ultimately the federal government, and politically it seems unlikely, but the state from saying that discrimination based on sexual conduct or orientation is a matter of violates a fundamental public policy? Is there any kind of limit on that? And there's a lot I don't know about tax law here. Is that even a concept that states use? And what would be the barrier to just moving straight from Bob Jones over to that as a matter of tax law?
So one of the questions Bob Jones really left open is who decides what's a fundamental public policy? In fact, there's a lot of the objections to the IRS's interpretation of the statute, and all what the court endorsed was the IRS shouldn't be deciding what's a fundamental public policy, whoever should be deciding. What the court held in Bob Jones is, at least for federal tax statutes, the question is what's a federal fundamental public policy, and that's not decided by a single branch even. They looked at Supreme Court cases, they looked at executive branch actions, they looked at congressional legislation, and they said, you know, the overwhelming weight of the evidence in this particular area is that prohibiting discrimination, racial discrimination in education is a fundamental public policy, regardless of what else may be. And interesting enough, since then, the IRS has not found any other fundamental public policy, possibly racial discrimination more generally, because it has some minor rulings in other contexts. So if a state government tried to say, well, our state fundamental public policy is X, is, we don't, no sex discrimination. I think sex discrimination is much more likely to be found in public policy than sexual orientation discrimination, at least in the foreseeable future. The question then becomes, well, for the state, it would have to be for their state charity laws, which are much, frankly, less important in the sense that the state tax benefits for being a charity tend to be much less than the federal benefits. And for the federal government, the question then be, well, even if the Congress said discrimination against women is a fundamental public policy, the question is, does that line up with what all the other branches are doing? And then the IRS would have to say, well, given the overwhelming evidence, we think it is, and then you'd have, of course, have inevitable litigation based on that. So the Supreme Court ultimately decide, is there enough to show that? So I guess the answer is no one agency or even branch may have the ability to make that declaration, and the IRS has, to its credit, been rather timid in trying to make that determination in any other context.
So can I ask a quick follow-up?
Sure.
So after Bostock, there's a question about whether Title IX is, the interpretation of sex discrimination in Bostock applies to Title IX. So currently there are pending regulations that would have applied in the Title IX context. There's a policy letter that says it applies in the Title IX context. The USDA has applied it to the free and reduced lunch program, which it turns out to be really important because many private religious schools don't get federal funds except through the free and reduced lunch program. So isn't that like, everybody's doing it? I mean, the USDA is like determining their policies based upon Bostock now, in distributing milk money.
Yeah, so I think that the argument's there. Now here's the other little hitch, which is a tax law hitch. The IRS has to be the first mover. That's because no one has standing generally to challenge tax benefits enjoyed by somebody else. There's actually a case involving abortion issues, and I think the Catholic Church or a subdivision of the Catholic Church that held that, among other things. So unless the IRS decides from its great, strong political position it currently enjoys to adopt that position, no one can force it to adopt that position. So and the IRS is politically relatively timid, which again might be a good thing, so it would have to adopt that position, and then it would face litigation, probably all the way up to the Supreme Court, of whether it's risen to the level of fundamental public policy, which would also put Bob Jones potentially on the block, because there are a lot of people from a lot of different perspectives that have criticized the Bob Jones University decision as a statutory interpretation matter or otherwise. So that's another reason the IRS might not want to go there in the first place. But it's about, but the IRS have to move first.
We have time for one more question? Yeah.
So I got two questions. Lloyd, my question was about the logic of the laws. It's not an unconstitutional conditions case, but does that serve at all to undermine the idea that tax is different, and that, and then Michael is more, talk about distinguishing regulated entity versus regulated program. What would be, if regulated entity is the program, right? The government wants to see LGBT leadership in all organizations, so they'll give people $5,000 if they have leadership.
Okay, so the Walsh case we've all familiar with is the case where there was a Establishment Clause challenge, and Free Exercise Clause actually, challenge to the property tax exemption in New York for religious organizations. And the standing is, well, that's a benefit to religious organizations, the Establishment Clause problem here, right? And the answer was, well, it's part of a broad exemption granted to a huge range of charitable nonprofit organizations, which happens to include religious organizations, and that's permissible. That's not establishing religion, it's not specifically benefiting religion, just religious groups are included in that. And that's often cited as supporting, well, that's why you can have tax benefits for religious organizations under federal tax law, too. And I think the issue there is that it was seen as part of the sort of Congress has created, and state of New York and most states have created these broad category of entities that will give tax benefits to And the conditions we assign, like it can't have private benefit or private inurement, like it can't be against federal policy, that's intrinsic in this charitable category, which has centuries, going back to England, historical legacy, which I think gives it a lot of emphasis. On the program versus entity issue, I mean, my initial take, which I'm still thinking about before I finalize this paper, is that it's harder for a state or the government to say, well, if we're going to give you tax-exempt status as a charity, then these conditions apply that really change your fundamental character, going back to the mystery concept here. Like you have to have LGBT leadership, even though you fundamentally object to same-sex relationships as a religious matter. Lobbying and political activity is different because that's a very distinct activity. It doesn't permeate your entity, and you again can shut it off into a non-benefited group.
So we are out of time. Thanks, everybody, for being here, and thanks again to the Law Review.
That concludes our second annual Law Review Reflection Symposium on Religious Liberty. Thank you all for coming. I want to thank Nicholas, our editor-in-chief, for steering us along. I also want to thank Lorraine, senior symposium editor, who did a lot of work on this symposium and helping with the authors. And thank you to all of our wonderful authors for making time to be here and participating in this very insightful symposium today. Thank you.